and the audacity to come here and take that stand and blame everybody else.
The audacity you're talking about is actually just a constitutional right that you're circumventing.
And the purpose of the jury trial system is to seek the truth. Not to seek doubt, it's to seek the truth.
It's not your job to seek doubt. We're not. Doubt is a consequence of you weighing the options. You might just find doubt. She's saying you're not supposed to find doubt. You're supposed to find the truth. How can a judge allow her to say you're not supposed to find doubt?
In this episode, we break down the question that no one wants to ask, but we did. Was this about justice, or was this about punishing Hannah Payne for some other reason? Please stay until the end. Give it a chance to breathe, because what you're about to hear might change how you see this entire case and possibly the entire criminal justice system.
I'm John. I'm an actual real-life 911 dispatcher. I've been doing that for about 9 years. I was a correctional officer before that, if that matters at all. But joining us, as always, is our host, a podcasting partner with police benefits, Drew Breezy.
Let's go to the case at hand. I think, though, you're going to see a very different side of the state. Remember, this is supposedly
they represent the people of Georgia.
They represent the people of Georgia. So let's get into it, John. What do you say?
Let's do it.
I mean, not that it has anything to do with it, but my entire life until I was 18 and my grandfather passed away, I was going to be a police officer. And on May 7, 2019, she got her opportunity.
All right. First things first, I thought when I first heard that it was going to be basically a slam poetry session, because that's how it started out. Turns out that was a quote from Hannah Payne, that she's like, she always wanted her chance to be a police officer. This is how they want to paint her. Okay. Now, the first thing you're going to notice, because I noticed it as well, is that they put this photo. This is what the jury sees. This is the PowerPoint presentation that the jury's looking at. Notice Hannah Payne's picture. She's in the picture. She looks in a menacing stance. She's got a gun in her right hand, so you see the gun. What don't you see, though, John?
We can't see anything that Kenneth Payne is doing. We also can't see where her left hand is at.
And you can't see what else? You can't see the front of the vehicle with all the damage in it, and you can't see her Jeep anywhere.
Yeah.
So they want you to believe that this was just a woman who jumped out of her Jeep and ran up to this Kenneth Payne. And that full photograph tells a different story when you see it in its entirety.
So you're saying even this photo was cropped?
Yeah, it's cropped.
And
oh, hold on a second. So we got to go back just a little bit. So I do believe that this photo was cropped.
And as a result, 62-year-old Kenneth Herring, who was unarmed and minding his own business, was chased down, detained, shot, and murdered by this defendant.
Do those words evoke any kind of emotion with you or anybody else?
If I was a normal person, yes, they would be considered very inflammatory and what I would call prejudicial language if I was a defense attorney, but I'm a non-attorney spokesperson, Drew.
I think that in the era that we're talking about, this trial being 2019, this was 2023 when this closing argument happened. The term unarmed was never really in prominence until unarmed black man became with the Michael Brown case. So now all of a sudden, this guy is unarmed. He's minding his own business. He's chased down. He's detained, as in, am I being detained? Am I being detained? This is all language of like this ACLU driven rhetoric that police are bad, police are bad, police are bad. Now remember, they started off painting her out to be a wannabe police officer. Now they're tying in unarmed, detained, and all these other inflammatory statements, in my opinion. That's what a closing argument is, by the way. It's to sway the jury, but I think you could probably do that with the facts a little bit better. But
And how do we know she shot him? Because we watched Officer Rich's body cam. And when he asked, who shot Mr. Herring? She said, I did.
is that what she said? I think she may have said, I did.
Am I allowed to be put off by axed? Like, if you're an attorney and you have gone to school after high school that many years and you're still saying axed, and you're someone who speaks professionally for a living, am I allowed to be put off by this, or am I going to be labeled as racist for having a problem with axed?
The truth is, John, no, you're not allowed to be.
Okay.
The actual truth is you should be, and I agree with that. I agree that not everybody had the benefit of a wonderful education and a safe environment and clothes on their back and all of that. But I don't know.
She's a lawyer. She makes more money than me, so
I would call law school and being hired by a prosecutor's office, being articulate enough to be in a murder trial.
See, I'm just cynical enough to believe that's affectation. I don't think that she necessarily speaks that way, but I think that it's possible, depending on who the people are in the jury, that, and I think what you're alluding to, I don't know. I don't know if I want to go down this path, because I don't know if I just want it to speak for itself and be self-evident, or if I want to be labeled a racist by calling things out. But if we are going down an inflammatory path of this is a case of white versus black, I have to wonder if that's an affectation. And I'm officially retiring discussion on this subject, Drew.
Okay, fine if you want, but I'm doing the same thing, and I hate dancing around subjects like this, and this is what makes me authentically me. I'm gonna hit this head on.
I mean, about the axe thing. I'm not going to discuss that.
I get what you're saying. I don't know that it's an affectation. Like, I don't know that she's intentionally doing that. Maybe she's just, that she was just raised saying that, and she's.
I'm just saying Barack Obama dropped all his G's at convenient times too. So
got it. I am saying this. There is a certain. There's a certain cloud over the country that the criminal justice system is prejudicial, in that there's two tiers, and that it is stacked against Black America. I am showing you that this is the opposite, that we should not be worried about the word axed. We shouldn't be worried about the prejudicial language that's coming from this prosecutor. We should be looking at the defendant's guilt or innocence. And we shouldn't be, but just as you say, like, we're not going to overtly talk about this. She's not overtly talking about it either, right? She is planting the seeds. She's saying unarmed. She's talking about this, and she's talking about that. Unarmed is a fact. I get it, but it's not as she's painting it out to be. And I'm kind of hitting in this head on. Like, what do you think, America? I don't, and I'm telling you as harmoniously as I could tell you. Michael Jackson said it best. It doesn't matter if you're black or white. And I'm telling you, if you are my black brother or black sister, I don't care. I want the same for you that I get, the same treatment, the same everything. I've always wanted that. And I'm not sure that we're doing that here. And that's why I bring it up. And I want to say, like, I hate if the shoe were on the other foot argument. I really hate, because it's a bunch of, it's just a bunch of supposition. But if the shoe were on the other foot, if we were, we hear so much about our dog whistles, and we hear so much about, well, you know what they were saying.
And the coded language, yeah.
And coded language. No, I don't know what they were saying. I know what they were saying, and I know what I'm hearing. It's not necessarily what you think it is, though. So let's just hope that's not what it is. But I don't know. We'll see.
Can I ask when the time is for rampant speculation? Because we're talking about this guy being unarmed. And he, at one point, Kenneth Herring says to Hannah Payne, and I know I'm just delaying the episode from ever happening, but he says, I got something for you. And of course, the contents of his vehicle would never be admissible as evidence, because it would be irrelevant, because obviously he never laid his hands on it. But we say that he's unarmed, and he was unarmed at the time he was shot, unless we want to quibble about who had possession or control of the firearm. But he said, I got something for you. And so I wonder if he was truly unarmed. I'm just going to throw that out there as rampant speculation, because I honestly don't know the answer, because I didn't toss his vehicle. I don't have evidence to the log of whatever was seized or cataloged. So I don't know. Just rampant speculation.
When items in the red truck were processed, police found a handful of items that may have supported her claims that Kenneth had been reaching back into the vehicle for a weapon in order to harm her. Amongst the mess inside the vehicle were a few heavier tools, a flashlight, and most notably, a knife. The knife was located amongst other items in the back of the passenger seat. It was deemed by law enforcement to have been accessible from the driver's side, but in their opinion, it was no more relevant to the investigation than any other of Kenneth's tools. It was Hannah's word alone that Kenneth had been reaching for something to harm her with at all.
She testified under oath, and not only did he say, I got something for you, he reached behind his seat, and his car was full of tools. So, look, you can call it unarmed if you want, in the sense that, yeah, no, he wasn't holding a gun like she was, until he was, because there was a wrestling match over the gun. So
yeah.
You can tell me all day long that Mike Brown was unarmed, but he wasn't. He was unarmed at the time he was shot, but he wasn't unarmed because he tried to wrestle Darren Wilson's gun away from him. The DNA shows it. Department of Justice investigation shows it. The Department of Justice's Civil Rights Division separate investigation shows it. Everybody shows it. It's no longer in dispute. It's just never been corrected. The record's never been corrected. And as a result, we are in 2024, and we're still talking about unarmed black men being shot.
Drew, why is the truth so elusive? Why do we have to sit here and talk about these things until we're blue in the face and we can just never, and no one ever knows anything?
And this is, so John, that's a great question. And this is why I say, I kind of can't believe this is coming from the prosecutor. I'm supposed to be on the prosecution side, so to speak. Like, we should never take sides. The goal of any testimony or any law enforcement investigation or whatever should be the truth. And that's it. That's where it ends. The truth should be put up to the people to decide if guilt or innocence. That's the scale of justice, right? But it's just not what's happening here. And it's not what's happening in America either. I think everyone's using influence and prejudice to say, look, this is prejudicial against law enforcement. You're going to hear the rest of the argument that she's just not saying it, but she's implying law enforcement bad. And don't forget, in this era, you had a sheriff that was indicted. You had 4 corrections officers that were indicted. Family shocked at jury decision to not indict officers in inmates' death. This is the same Clayton County, Georgia grand jury. They decided not to indict 6 Clayton County jail deputies charged with involuntary manslaughter in the in-custody death of an inmate. Essentially what happened in this case is that they're fighting with him. You can see in the upper corner there, obviously trying to jump, for whatever reason. I think they ended up tasing him, and there were 6 deputies involved, and he died. And their response to that was, okay, well then let's indict them all for for some type of manslaughter. And the grand jury came back and said, how about no? The police training site just outside of this area that was overrun by Antifa, and they let those people go free. You have the prosecutor who's saying, I'm going to make it a point to make a point out of all of these gun cases. This particular DA, her name is Tasha Mosley. She is definitely I don't want to say anti-gun. She has a focus on gun safety, which could be interpreted as a method of gun control. Who's going to argue against gun safety, John? But let's take a listen to one of her PSAs here.
This year alone, the District Attorney's Office has seen a rise in violent cases involving guns as well as accidental incidents. My office is prosecuting more than a dozen cases involving guns where these situations could have been avoided. Citizens of Clayton County, we need to put the guns down. Not only are our older citizens losing their lives to gun violence, but our babies are dying too.
Or I hate to say that I feel in this case and several others, there's a difference between justice and revenge. And this is a revenge case. It just seems to me
this is all mob justice, but the mob can be lazy now, and they don't have to do anything. They can just put pressure on our courts. There doesn't have to be anyone standing outside. There doesn't have to be burning effigies and hangman's nooses anymore. We can just have the mob right there implicitly, right in the courtroom, right on the bench.
the mob reads the headlines, John, and that's why I like to get into the fine print. And that's why we have 9 episodes of the show. And it may be uncomfortable for some people to talk about. And I get it. It's uncomfortable for me to talk about. I want nothing but peace and love for the whole world. It's not happening, and it's not going to happen until you quit just reading the headlines. That's
we better get back to this, because I know I'm going to be outraged for the next hour, and the episode will be over. So we had better just keep going.
And
beyond outraged.
you don't get the death penalty for committing a traffic infraction. And you know how much entitlement you have to chase somebody down?
Entitlement equals privilege.
Yeah, that's coded
Detain
language right
them.
there. If you want to dog
Jump out
whistle.
your car
Chase somebody down, jump out your car.
and run toward a stranger. He didn't know her. He didn't know why she was approaching his car, and demand that they do anything.
All right, this is where I have issue, and I know that you and I.
Well, why is she taking the side of a lawless person? She's sitting here saying that a person fleeing the scene should not expect to be brought to any kind of consequences. I'm sorry, but in this society, not only do we have police and we have law and order, but we do have the power of the citizenry to perform arrests in just cases. And she's saying that the criminal was completely justified in what he was doing. How dare someone take any actions? You can argue whether or not Sarah Payne should have marched up to that line, whether or not she thought she was a cop, whether or not she wanted to be a cop like her father or grandfather or whatever. But this is not even an issue of a traffic violation that he got the death penalty for. He got the death penalty because he assaulted somebody. So if we're going to start getting into hyperbole about what you get the death penalty for, let's at least start at the place where we actually should be, which is assaulting a woman. This has nothing to do with the whole traffic case that we just spent 8 episodes showing. The whole thing gets painted in terms of this is a traffic stop where we have someone going out there and acting like Batman. The truth is, maybe she should or should not have been there. But when someone reaches out and grabs you, everything of the foregoing really doesn't matter, because Kenneth Herring did not have to reach his hand out of his Dodge Dakota to do shit. He could have had the window rolled up. So why is she taking the point of view of someone who is driving intoxicated, rammed into a vehicle, and is putting countless other people in danger? I'm not Hannah Payne's biggest fan, but why is she taking his side?
Exactly.
She's the prosecutor.
Exactly. I am not in this. And this is what I've been saying since episode 1. And this is why people think I'm crazy about things like this and Uvalde and everything else. In order to be a good investigator, you have to think critically, like down to the minutia. And I really think that you need to delve into the minutia. And I think that this case or justice deserves this, because you can take somebody's life, like on the street as a cop, just with your gun. You can also take somebody's life with typing out an affidavit. You can also take somebody's, like Hannah Payne's life, and whether you have sympathy or empathy for her or whatever, you can also remove her life. 22 years old, 23 years old. She's in prison for the rest of her life over this. So I am just about the truth. And if we're going to have a fair and equal justice system, it needs to be fair and equal. And all of the details matter. And I think that you need to prepare yourself for chest pains.
You cannot speak from the truth and proceed from a fundamental lie, though, that said you don't get a death penalty over a traffic violation. That's not what happened.
Yes. That's it. Not only that is the social media rhetoric that is causing police officers to take their own lives. That's exactly what I keep talking about. That's the social pressures that we receive when you say, well, Eric Garner was killed because he was selling cigarettes. No, Eric Garner was killed because he resisted with police. Whether they used too much force or not is a different story. He wasn't killed because he was selling cigarettes. Name any case. And the one that the people tend to use too much is Trayvon Martin was killed just for walking through a neighborhood. Well, he wasn't killed by police, first of all.
Yeah.
But secondly, he wasn't just walking through the neighborhood. The trial showed that he had George Zimmerman's head and was bashing it against the concrete. Again, was this a matter of George Zimmerman stepping into a pile of something he shouldn't have stepped into? Maybe. But does he have to die because of this? It's the same thing with
No,
Hannah.
you don't get the death penalty for being a meddling kid. How about that?
Right. You don't get the death penalty for being a good citizen. And that's why I say maybe I got a bad rep from the first couple episodes where I was trying to say, look, you don't have to be a good citizen, but how about this? Since 9/11, we have been pushing, see something, say something. And she was specific. Hannah Payne saw an accident. She pulled off to the side of the road. It's a dream to investigate an accident and have a witness stick around. Half the time you can't get the people that were in the accident to stick around. And a witness not only stuck around, she was given information by somebody with a badge on their belt that says that guy's intoxicated. Something's not right. Inebriated was the word he used. Okay, so when she took off after that guy, she was not taking off after a guy to murder him. She was taking off after an inebriated motorist. And that's it. That's kind of where we should be with this case, but it's not. And I'm telling you, prepare yourself for chest pains.
He didn't have to listen to her. He didn't have to do anything she said. As he continued to ask her, who are you? And the audacity to come here and take that stand and blame everybody else. Now, before I jump into all the facts and all the evidence that you heard today.
I hate to keep interrupting, but the audacity.
I have to interrupt. She said ask. She said ask just fine that time.
Oh, thank you, John. The audacity to sit on the stand where no one else does. No murder. There aren't, I'll say 1 out of 10 murder suspects take the stand in their own defense. She sat on that stand and she handled questions from both sides. It was very difficult. So
Yeah,
don't say she had the audacity. That's like saying she had the audacity to remain silent. Well, guess what? That's a constitutional right. That's not audacity.
It takes bravery to go be cross-examined when you're fighting for your life.
Yes, that the audacity you're talking about is actually just a constitutional right that you've that you're overusing, or you're, you know what I'm saying, like that you're circumventing, sort of. Not
you know what pisses me off the most about this lady is that she has this ideal, probably somewhere inside of her, that amounts to self-justification, right? Where she could say, I can push as hard as I want to push, and I can call her audacious, and I can proceed from completely fake precepts like this was about death penalty in a traffic stop case. And she can have this idea that if I proceed as zealously as possible, and if the defense attorney proceeds as zealously as possible, those two efforts will cancel each other out and will arrive at the truth. And the truth is when you're a prosecutor, you have a standard to bear, because you are only going to bring charges against people who deserve to be charged in the first place. And as we break down everything that she was convicted of, the charges that we're dealing with are ridiculous to start with. So I especially hate this prosecutor, and I especially hate whatever's going on in her mind, that she says that she can just do whatever she wants to do, and the defense attorney had better step up to the plate because the compromise between their two opposing forces equals justice. I've heard this kind of rhetoric from academics that it's only a rigorous defense and a rigorous prosecution that will mete this out. No, if you're a good prosecutor, you're not going to be going after your own citizens for your own political clout, which I'm sure we will unpack at some point, Drew.
I just want to say we're at 43 minutes and we're only like 5 minutes into the
cheese and crackers. We are bad at this, Drew.
All right, hold on a second. I will also say this. This is why I still say, at the risk of, I don't care if I lose 3,990 followers or subscribers over this. I'm talking about, first of all, my opinion, my experience, which for some reason is discounted if we're talking about racism or whatever. But I'm trying to say, I was baited once into an argument with somebody who was, it was over Uvalde, by the way, but all of a sudden she started in with this, you realize I represent the Black community, right? And I don't, and I was like, good. Like, I don't give a shit. I don't care. I don't care about the fucking Black community like that. I care about the same as I care. How about the community? How about we just call it the community? So I was baited and painted to be a racist. Okay, fine. I know it's in my heart. I'm good with it. I know when we get up there to St. Peter, St. Peter's going to look at me and say, come on in. And they're going to make her stop and explain a few things. Okay. Don't play this. I'm not going to fear this racism anymore. I'm not going to fear this being called a racist anymore. I'm done with it. So let's get back to it. Can we?
I want to talk a little
Yes.
bit about what your duties are. You're to be a fair and impartial juror, honestly seeking the truth. And the purpose of the jury trial system is to seek the truth. Not to seek doubt, it's to seek the truth. You have a duty to follow the law,
What?
and you are bound by the instructions.
Right.
It's
Don't
not your
pay
job to seek doubt. We're not. Doubt is a consequence of you weighing the options. You might just find doubt. She's saying you're not supposed to find doubt. You're supposed to find the truth. How can a judge allow her to say you're not supposed to find doubt?
John, don't make me say it.
And the law given to you by the judge. Now, you shouldn't consider anything that's outside.
Okay, listen to this.
Is that the black hole that we're falling down into?
Listen to what she says you shouldn't consider, and remember our priming episode. And if you haven't seen our priming episode, go back and watch our priming episode. Remember, just hear her out and hear what you shouldn't consider.
This circle. Passion, public opinion, dislike of the police, any sentiment, sentencing, prejudice, penalty and punishment, conjecture, whether you disagree with the law or if you have any sympathy for the defendant. The only thing you should consider is the law, the elements of the crime that I'm going to discuss with you, any testimony that you heard during this trial, any expert testimony, and you will determine the credibility of the witnesses, any photos, any audio, any videos that you saw, the physical evidence, and your common sense. We don't ask that you leave your common sense at the door, and any corroboration. Now,
If you don't want me to talk about, if you don't want me to think about anti-police sentiment, why are you putting the thought in my head?
Yeah,
If I'm a juror,
why is this being discussed right now? You know, at the time when the round was discharged from the firearm, there was no police officer there. So why is that being spoken about?
now, you may consider the personal credibility of any witness that took the stand. And it may have been shown in your presence, in their presence and by the evidence. So this applies to the defendant as well. What was their demeanor? Did they have any reason to lie? Did the facts they testified to match the evidence? Was there any corroboration? And is what they say believable? We presented several eyewitnesses that Attorney Tucker discussed. And you heard direct evidence based on things they saw and what they observed on May 7, 2019. Now, even though Attorney Tucker tried to twist their words, misquote their statements,
which is exactly what she did with that entire transcript of the 911 call in the last episode that we
How
had.
can this be viewed as the officious behavior of an officer of the court?
I'm
Is he
telling
not
you.
allowed to object to that? Because for God's sakes, he says, you know, that this attorney's twisting things, you know, and they don't discuss anything substantively. She's just saying, yeah, he was twisting the words. How could she, as an officer of the court, be allowed to do that? Because it's an attack on him. It's an attack on him professionally. I just don't get
And
that, Drew.
It's a total projection. She completely twisted Hannah Payne's words the day before, if not that day, in when she was cross-examining her. And go back and watch the episode. It's very clear that she's using the transcript to twist her words and not using the recording of the 911.
they all stood firm in what they saw.
And by the way, she's saying all of the witnesses are credible. The defendant is not.
And what was consistent between Ms. McCraney, Ms. Rosser, Ms. Jackson, and Mr. Williams was that there was only one aggressor on May 7, 2000.
Okay, so I had a little note of there, none of whom were had the privilege of knowing what happened to that point. All of the witnesses she just named came in after the fact. They came in for the confrontation, and they're hanging their hat on use these witnesses as your star witnesses because they saw the confrontation, not what led up to it. What led up to it doesn't mean anything until later when I bring it up. And I think that that is a horrible thing to do. Like, if they're witnesses, they're only witnesses to that one little part. They're not necessarily witnesses to the entire case. I'm not saying that they weren't credible, and I'm not saying that they didn't tell the truth. And you know, they saw what they saw, but
you could say that they're credible, but their testimony may not be reliable or valid. These people have been waiting 3 years and have been relying on memories of something that happened that day. No one, and this is just basic psychology. I'm not taking anybody's side when I say this, because whatever to Hannah Payne, but no one has been more invested in the outcome of this than her. No one had a front row seat to all of her actions better than she did. So if we're just going to say, well, you know, everyone who was present there except her is reliable and valid, these witnesses, they don't have the same stakes that Hannah Payne does. They don't have the same cards in the game, the same skin in the game that she has. They committed their word to something, and then 3 years go by and they remember it or they don't remember it or whatever. And then ultimately they're asked to testify on it later. They're going to corroborate whatever they said the day of, because that's just a human self-justification thing. And it's also like, I guess I better just stick by whatever I said on that day. So let's not talk about validity and reliability of these witnesses versus Hannah Payne. They're at least the same.
how about this? I heard a very wise general, Army general, one time, like a 4-star. He was giving a presentation on leadership, and he talked about, I can't remember the terms he used, but he talked about participation and commitment. Okay. So there's a pig and a chicken involved in this story. The pig and the chicken are going to provide you, John, with breakfast. You're going to get some nice, you know, sunny side up eggs and some smoked bacon, right? Mm-hmm. Well, the chicken is going to participate. The pig is committed.
Yeah.
So, hopefully you got my point here. I mean,
yeah.
2019. And that was the defendant.
In other words, the witnesses were there. Hannah Payne lived it.
Yeah.
Now, you heard testimony from the defendant yesterday. And, you know, she stated that she never heard 911 tell her to not chase.
So snotty.
And she didn't say that.
And then when I went through her testimony,
she's going to contradict
in the
herself
transcript
later.
of the 911 call, they told her 4 different times, either twice, to go back to the incident location. And they told her not to follow him. But she said, based on her perception and what she believed they meant, was that she should follow him as long as she remained safe. Now, it's not a memory contest. These events happened nearly 4 years ago. And the witnesses got on the stand and they testified to what they remembered that happened on May 7, 2019. And for the most part, they gave you everything. Now, you can imagine, you know, if you went.
For those of you who are not watching but listening, she's, and I'm a big fan of the body language thing in this. She said, those witnesses, they gave you everything. And she shook her head no, which is an indicator that she's talking in the negative. She's like, they gave you everything, which is not really. And your muscular system, your autonomic nervous system takes over when you're having a conversation like this, and you can't fight that. Like you're automatically going to shake your head no, because you know that's the truth. It doesn't matter what comes out of your mouth. Okay, so generally those are taken in totality and in clusters, but I think it's poignant that she's like, they gave you everything, and she's shaking her head no.
To a wedding, and you know, you went to the wedding, you told your mother, you know, the bride's dress was beautiful, the food was good, and you told your dad, you know, they had a great open bar. The DJ was real nice. And you told your friend, you know, the invitations that we received, they were just beautiful. Now, you may not have told each one of them all the details or specific details of what happened at the wedding, but what was consistent amongst the story is that what? I went to a wedding, and all of the witnesses were very consistent. That when May,
I'm just saying, under this example, the only consistency is that they witnessed something.
Yeah.
It doesn't matter. It doesn't, like, yeah, okay, so they went to a wedding. It doesn't necessarily mean that the catering was good. It means that the catering was good to that person. It doesn't mean that the open bar was a highlight of the wedding. The bride and groom don't think so. They think they were the highlight of the wedding. I've been sober for 15 years. I don't think the open bar is a big deal unless they had NA beer. You know, it's all relative speaking, but it's all relative.
What she's saying is that if you take enough subjective experiences, you reach objective truth, which is not true.
That's not true at all. You can't. Okay, back.
in 2019, Tiana McCraney advised you.
Hey, just on the off, look, take a look at the witness list in this case. Google them, Google image search them, and make your own judgments. I'm not even going to bring that up.
That she observed the defendant travel around Mr. Herring's vehicle and block him in. She stated that the traffic on that day was very congested on Riverdale Road. It wasn't moving.
Remember those words. Traffic that day on Riverdale Road was congested. People weren't moving.
And when I asked her, was there any way after she blocked his vehicle in and detained him, could he get around her? Could he move in any way? And she said no. And what she also observed was
the photos, when you see him in the proper frame, tell a completely different story, by the way.
The defendant jumped out of her vehicle, irate and aggressive, and immediately run toward Mr. Herring's vehicle, screaming and yelling for him to get out of the car and cursing at him. Now, when you watch the defendant's interview, she never mentions to the detectives at any point in time that she yelled at him, that she screamed at him, and that she demanded that he get out of the vehicle.
She answered their questions. She wasn't asked to she answered their questions, and she did so truthfully. We covered that extensively. So when she asserts that she never said that she swore at him, and she's painting that to make her sound like she's hiding something, and she wasn't. If she were hiding something, she wouldn't have held the 911, the recording. She wouldn't have held the recording device anywhere near.
I wonder if she's going to mention to the jury that nothing that the attorneys say is considered testimony, because she's testifying right now.
That's true. That is what
her characterization was. I walked up to the car. I held the phone.
Theater.
And I said, I have 911 on the phone. And they want you to go back to the scene. And that all of a sudden, the victim just became very irate.
All of which happened. All of which provably happened.
Grabbing her and pulling her into the car. And that's not what any of the witnesses saw. And you also heard from Ms. Rosser, who advised that she saw the defendant outside of Mr. Herring's vehicle punching him, being very aggressive.
Which completely corroborates Hannah Payne's story.
Screaming and yelling. And you also heard from Ms. Jackson, who notified you that as she was leaving work and she made a left onto Forest Parkway, that she noticed the defendant's Jeep come flying down Forest Parkway, almost running her off the road and other vehicles off the road.
So moments ago, traffic was so congested and vehicles were stopped and couldn't get anywhere.
Swerving in and out of traffic, which is ironic because she stated the only reason she was trying to get Mr. Herring pulled over because he was going to harm other drivers on the road. She wanted.
Drunk driving killed 10,142 people in 29, according to the National Highway and Transportation Safety Administration. I just want to point that out.
Wanted other people to be safe. And
she's mocking it.
when she caught up to Riverdale Road, Miss Jackson got up to Riverdale Road, she noticed that the defendant here, had caused an accident. She didn't know that she had cut Mr. Herring off and pulled in front of him. But what she did know was that she just observed her driving very irately. And so she pulled over because she was interested in seeing what happened.
Doesn't that sort of sound like what Hannah Payne did? She painted her as someone who should have minded her own business. But that's exactly what this witness did. And now she's portraying her to be the star witness in this whole case.
Yeah, but what would happen if the witness had been grabbed by Kenneth Herring and felt like she was in danger for her life as Kenneth Herring was hitting the gas on the vehicle and saying, "I got something for you, bitch"? Then what would be the situation would the witness be in? Hannah Payne's position.
Right.
And what she saw was the defendant very aggressively banging on what she thought was Mr. Herring's window. But then what she realized was that she was actually punching him inside of the vehicle. And what Miss Rosser and Miss Jackson remember was her pulling that firearm. And when she pulled the firearm, she pointed the firearm in the vehicle. And what?
Here's the deal. You're going to hear a characterization in a minute that does not match what she just said, because she's saying all the witnesses remember her pulling the firearm. And what she's trying to tell the jury is that she jumped out of her Jeep, pulled her gun, and ran up to this guy. And that does not match.
What they recall is that she immediately shot.
They recall that she immediately shot. They didn't, like, she's telling the jury that she immediately shot. She's not saying, I mean, there was a little struggle.
This is being characterized as testimony. Now, everything that's gone before this, all the witnesses, and including Hannah Payne, have discussed what's happening. But she's getting up in front of the jury and she's condensing it and muddling so much this is just her version of what happened. And she's saying, "Oh, well, the witnesses said this," and it's just it doesn't matter that what she's saying is fundamentally untrue. This is an exact reflection in our politics, Drew, where people just get up and say things that are not true. People are so confused by it. People are so hesitant to think critically. People are so hesitant to parse things out in order to reach the truth. They're just like, yeah, that's, generally sort of what happened. Everybody was at a wedding, right? It doesn't matter, the specific details. So,
right.
The defendant is charged in count 1 with malice murder.
I wanted to add this. This is a little bit lengthy, but these are the counts: malice murder, felony murder, aggravated assault, felony murder, false imprisonment, possession of a firearm during a felony, possession of a firearm during a felony, possession of a firearm during a felony.
Count 2, felony murder. Count to prove that she committed.
Okay.
I know there was only one death in this case, and we charged.
This is their explanation.
Now, the state of Georgia allows us to charge murder in various ways. And you don't have to pick one. If you believe that the state has presented sufficient evidence to prove that she committed counts 1, count 2, and count 4 beyond a reasonable doubt.
This is the exact same thing. I am not going to stand on a Trump soapbox, but there was a prejudicial trial that took place in New York in a prejudicial jury. And this is what exactly what that Judge Mershon let happen. You get to smorgasbord all of these charges, and if you see guilt beyond a reasonable doubt in any of them, all of them are true. And that's not fair and just, in my opinion. You can have one without the other, because what she's going to tell you later is that this count doesn't require malice, and this count doesn't require intent. which
Well, then why
tells
do we
me-
have all these different statutes, Drew?
Right.
Because malice murder is malice of forethought, meaning she intended to
Yes.
go over and execute this person. That's entirely different than, say, some degree of manslaughter where through deliberate indifference or negligence or recklessness that you've caused the death of another human being. So you should have to pick one, because Hannah Payne only did one of those. She either went over there with malice of forethought and decided, I'm going to kill Kenneth Herring, or she went over and just said, well, whatever happens, happens. You know, she had a certain recklessness about it. She didn't have both. So the jury should have to decide, what did Hannah Payne do? Did she have malice of forethought when she went over there? Did she decide, I'm going to commit murder? Or did she just have this recklessness, like I said? You cannot have it both ways. Why do you get to have your cake and eat it too when it comes to two different levels of murder that are created and distinguishable for different reasons? Because the ramifications for one being true and the other not are huge. That's why we have both.
Yes, and having it both ways is what allows the jury to be able to just smorgasbord pick what they want and call the whole thing guilty. And that's why I say that's not fair.
So she had no malice of forethought, and she was also just sort of reckless. Somehow she was both of those things. By the way, reckless means, what does reckless mean? Because people don't understand what that word means.
Well, she's going to
reckless means you have no reckoning. It means you're not thinking. That's what reckless behavior is. You have no reckoning about it. You're not thinking. How can you have malice of forethought, that thought, and also be reckless? You cannot be, by definition, both. You cannot be thoughtless and then thoughtfully murder someone.
It's kind of like saying, look, you either need, you can have, if you find the defendant had 50 cents or you find that they had a half a dollar, guilty either way. And
well, what it really is, flip a coin, heads I win, tails you lose, is what it is.
Yes, that's right. Thank you. I couldn't characterize.
You can enter a verdict on all of those counts. You don't have to choose one.
Yeah, you don't have to.
Now let's talk about malice murder. Malice murder is when a person with malice of forethought unlawfully causes the death of another human being. Now, what is malice? Malice is the unlawful intention to kill without justification, excuse, or mitigation. An intent may be shown in many ways. It can be inferred from the proven circumstances or by acts of conduct.
You just edited past the premeditated part, right?
I edited.
You didn't do it intentionally, but I just want to point that out, particularly to our audio listeners. Malice of forethought means there's premeditation, meaning she thought about it beforehand, that she got out of that car and she said, I'm going to go kill this guy. You cannot think those thoughts and also be reckless. And yet, this prosecutor goes before the jury and says, you don't have to pick one. She can be both.
Right.
It is the natural and necessary consequence of the act. So if you pull out a gun and point it at somebody, then you fire that firearm, then the natural and necessary consequence is that they may die. We believe.
If you pull, and she did this in her cross-examination, I can't tell you how many times I pulled out my firearm when I was a cop, but I never shot anybody.
No, you did it to impress people, to look cool at parties, to perform various magical tricks. There's lots of reasons for that, Drew.
To get right, because I was a little short on beer money. So I'm a sinner. So I'm the worst guy.
Trying to relax here because I'm just about to die.
Yeah, well, I'm telling you.
And we believe we submitted to you that the defendant acted with malice when she chased Mr. Herring's vehicle in her Jeep. She cut off Mr. Herring's vehicle with her Jeep on Riverdale Road, cornering him in, blocking his ability to move, detaining him. When she jumped out of her Jeep in an aggressive manner, immediately runs up to Mr. Herring's driver's side door, screaming, cursing, and demanding him to get out the car, motherfucker.
We didn't hear that.
She tells Mr. Herring that she will shoot him.
No, we didn't hear it because she held the 911.
The phone was in her hand the whole time. When did she say, "Get out of the car, motherfucker"?
It's not what the witnesses testified to. Therefore, you have to not listen to what that says, and you have to rely on the transcript, not the recording. That's why I'm saying this is all.
I'm just saying I never heard Hannah Payne call anyone a motherfucker. That's all.
I haven't either. That's what I'm saying. There were people that testified to that. So she's saying don't believe what you saw, and don't believe any of this other thing about what actually
The
happened.
entire encounter,
what
she
these-
had a phone in her hand.
Believe what this witness who thought that the bride's dress was beautiful said. That's what you need to believe.
Play it back. I want to
She
hear
draws her-
motherfucker, because that's a huge part of making the case for malice aforethought, is that she's calling this guy a
Cornering
motherfucker.
him in, blocking his ability to move, detaining him.
Detaining him.
When she jumped out of her Jeep in an aggressive manner, immediately runs up to Mr. Herring's driver's side door screaming, cursing, and demanding him to get out the car, motherfucker. She tells Mr. Herring that she will shoot him. She draws her firearm from her waist. She racks the slide with 2 hands.
Wait, hold on. She racks the slide?
With 2 hands.
So, okay, so to hold on 1 second, pause everybody, because this happens in movies and on my excellent case breakdown of Training Day, where characters just rack slides on firearms for no reason to look cool.
Right.
So
Right.
she didn't have a round in the chamber, and she racked the slide to put a round in the chamber. When and where did that happen, and who testified to that, and who is it that carries a gun? And Hannah Payne talked about going to firearms classes and her trigger discipline and the parts of a firearm. The idea that she got out of there and she's like pulling back the slide to put a chamber in there, or put around in the chamber, is something straight out of a movie that somebody made up. I don't believe that that's real at all.
And John, there were 2 safety mechanisms on that firearm. Remember, there's one on the handle and there's one in the trigger. So racking the slide with both hands is not something I'm buying. I mean, maybe it happened.
Designed to
I
make
never
her
saw
look like
testimony that it
Samuel L.
happened.
Jackson. That's what that statement is designed to do.
Yep.
And she shoots him.
But again, she's skipping the major part of this. She's just basically saying while she's getting out of her Jeep, she's racking the gun.
And you heard on the 911 call, you heard her say, "You hit my car."
How could she rack the
And she
gun
says that-
while holding the phone, Drew?
She didn't say that though. She said he hit my car. She told the 911 operator that. You'll hear it. You'll hear it plain as day. Not yet, John.
Right, shoots. She's also charged with felony murder. Now, when a person, while committing a felony, causes the death of another human being,
She's not committing a felony.
irrespective of malice,
Okay, so they're hanging their hat on the illegal detention, which is a felony, the false imprisonment. So they're saying, yeah, don't worry about her intent in this one. She committed the murder while committing a felony. And it's ridiculous. It's a ridiculous
so
argument.
now she both has intent, she doesn't have intent, and the intent doesn't murder. Or
And
the intent doesn't matter, excuse me. So
Right,
she can have it both ways, and it doesn't matter either way.
You can Yahtzee your way through this verdict. If any of them come up 2s, you're good. That's all we need.
and she pointed it at Mr. Herring, then he reasonably believed in that moment that he would receive a serious injury.
She can speak for the dead.
And therefore, the aggravated assault was complete.
So that's the felony. They're saying the felony is the aggravated assault with the firearm, which she's also being charged with possessing a firearm while committing an offense with the firearm. I don't know how that's not lesser included, but
I don't get how it's we're just doubling up here. We're just loading the docket.
And count 4, she's charged with felony murder.
no, they're doing that intentionally because they know that the more charges, the greater the chance of them picking one of them.
Sure,
to
yeah.
be guilty.
The jury's gonna say, well, they're not gonna say, well, none of these are appropriate. They're just gonna say which one is appropriate.
All right, so I want to get one last thing in to boil your blood, and then we might have to cut this into 2 episodes, believe it or not.
For the crime and felony of false imprisonment. Once again, intent to kill for this count is irrelevant.
They're saying, first of all, his Jeep was almost inoperable. Second of all, they're saying that because she cut in front of him that he was being falsely imprisoned.
He could get out
he
and run
couldn't
away.
go around. It's ludicrous.
And a person commits false imprisonment when she, in violation of the personal liberty of another, unlawfully detains another without legal authority. And false imprisonment is a felony. Now, if you recall, when the defendant was on the stand yesterday, she did not want to state that she...
Look at the picture on the right. Not necessarily.
Where's all that traffic at?
Yeah. Well, I mean, you know, this is long after, but look at the picture on the right. First of all, look at the picture on the left. His bumper's barely touching her tire. But look at the which it kind of goes against what Hannah was saying about, you know, the distance that she was traveling and all this other stuff while she was being pulled into the car. But look at the picture on the right. He could easily go around her. This is, and they're calling this false imprisonment. And this, by the way, is the front of the car that they didn't want to show you in the picture with Hannah with the gun out. They didn't want to show you that.
Blocked Mr. Herring's vehicle in. But this is what you see in this photo. And that's what you heard on her interview when she said, I found an opportunity and I pulled in front of him and I stopped him.
She's being punished for being honest.
So once she blocked his vehicle in and blocked his access, blocked his movement, the false imprisonment was complete. She had no legal authority to do this. She's not post-certified. She's not a police officer. She has no arrest powers. Nobody legally told her to stop Mr. Herring's vehicle. And you heard a lot of talk from the defense attorney that he could have jumped up the curb and drove down the sidewalk. There was no duty for Mr. Herring to retreat.
Okay, so that's
he doesn't have a duty to retreat, but he can retreat. But he's being imprisoned.
Yeah, but he can't. He couldn't retreat anyway. Or he didn't need to retreat.
He didn't have a duty to retreat. He had a duty to be imprisoned. Apparently, that's what happened.
She literally just admitted that all he had to do was pop the curb and leave, but he didn't need to. He
didn't have a duty. He didn't have a duty to retreat.
Right.
But she had that. But she had full power to imprison him. So either way, so he didn't have the duty to retreat, but I guess he could. God damn it!
And as you heard Ms. Jackson say, who drives on sidewalks?
Oh, who drives on sidewalks? Maybe people who don't want to be in prison or die. Are you fucking kidding me? If we're actually talking about high stakes of imprisonment and death, who doesn't drive on sidewalks? I'm a bad driver. I drive on sidewalks all the time. I drive on sidewalks when I want to. I'm very bad at this. Do not try to. She is infuriating me because she will make her case both ways. I think if you're a good prosecutor, and I think if you're intellectually honest, Drew, you make your case one way and you stand on that one way and you let the jury see it one way. You don't just say, well, it's all these different versions of the truth that together or separately amount to zero doubt. She is literally laying out multiple theories which contradict each other. And unfortunately, there's only one objective truth. How is this jury so completely snowed by this? Now, I'm not saying that they shouldn't just go with one version of what the prosecutor's doing. In fact, if she just laid out one case for her own self, maybe that would be enough to convince the jury. But what's infuriating to me is that she presents all these multiple theories that contradict each other. So she's lying out of one side of her mouth or the other.
So now, count 6 through 8 in possession of a firearm in the commission of a felony. When a person unlawfully has on his person a firearm.
So she's saying the three possessions of a firearm during a felony are for the 3 felonies. The 3 murders, or the 2 murders and the aggravated assault, or the aggravated assault and the false imprisonment and the murder.
Murder is a felony, aggravated assault is a felony, and false imprisonment is a felony. One of the most important parts
Check this out.
to remember as you deliberate. A person is justified in using deadly force which is intended or likely to cause death or great bodily harm, only if she reasonably believes that such force is necessary to prevent death or great bodily injury to herself or a third person, or to prevent the commission of a forcible felony.
Okay, so she was being assaulted. Does that not matter? She can't use defense to prevent the forcible felony of her own assault.
I made mention in the last episode, I believe. It's not even assaulted. If she's being pulled into the car and he's moving, you can make an argument that that is kidnapping. That's not false imprisonment. That's kidnapping,
Not
which
only
is
that-
a forcible felony.
Not only that, but the testimony that we heard was that
Reasonable
she was prepared to use force in self-defense. But the testimony that we heard from her was, I did not use that force. That while he was entangled with the gun went off, which we can believe. We can have at least reasonable doubt, which should acquit her. But somehow she's not able to use force in her own defense, which this prosecutor just made that case. But she didn't even use the force at all.
Belief doesn't just mean whether the defendant believed it. The question is whether it was reasonable for her to believe it. Would a reasonable person believe it under the circumstances that you've heard in this case? Was it necessary? To be entitled to self-defense, the defendant must have needed to use this force to protect herself from an imminent threat of death or serious bodily injury.
Like
or
assault or
forcible
kidnapping.
felony. The problem here is that a person is not justified in using force in self-defense if she is the initial aggressor. The defendant was the initial aggressor and therefore is not entitled to self-defense.
Oh, so she could be the initial aggressor, and then at no point she can come under assault.
Yes. I mean, that's the law. I get it, but she is missing a huge chunk of the story that she's not telling them, which was there was no intent to have this scuffle. The scuffle was, hey, get out of the car.
The scuffle was Kenneth Herring's idea. The fight was Kenneth Herring's
get out of the
idea.
car. She got a little too close, and he pulled her in. That's when the fight's on. That's when all of this
it's a tale
started.
of two aggressors, right? But there's only one physical aggressor, which was
Yes.
Kenneth Herring.
Whatever Mr. Herring did, once the defendant cornered him, aggressively
Cornered
approached
him.
his vehicle, and pulled out that firearm,
Cornered him, aggressively approached his vehicle, and pulled out that firearm. She is skipping some very important details in that timeline because,
There was a dress, there was a cake. What was it? I don't know.
yeah, she cornered him. She aggressively, okay, fine. We'll concede. She cornered him. She aggressively approached the vehicle. Okay, fine. Okay, what's the in between when she pulled the firearm out? Because
She was
a
grabbed
lot
and pulled into the
happened
vehicle.
there.
Yes,
Yes,
and she
a
just
lot
skirted
happened.
past that. Honestly, this defense attorney should have taken a page out of Matlock or Perry Mason and put the deceased on trial. I hate to say that, but this is so dramatic and farcical that's how the direction that we should have gone. This should have been a CBS drama.
She said that she cornered him. She aggressively got out of her car. Then she pulled her gun. There's a lot in between there. And when you're talking about somebody's freedom, you're talking about somebody's liberty for the rest of their life. That's the minutia I'm talking about.
It's crucial.
It's crucial. This is why I say, John, we started this whole thing kind of both saying, well, she got what she expected. She lit a match and she got burnt, right? And she's
going to need an onion because she just got stung.
We both kind of went, from the genesis, we were all kind of like, she should have shot the guy. And then we heard a little bit different. And now when you hear this closing argument, and whether you think she's lying or not, that's up to you. You heard the same testimony I did. Whether she's lying or not, the prosecutor, she's lying or not, she's definitely painting a different picture than what was testified to. She's relying on her witnesses, which is fine. That's her job. I just don't know that this, kind of like any interview or interrogation, if you're spending most of your time selling me on something without telling me the story, then I that's the smoke. In this case, I see flames. I don't see smoke. I see flames.
But I get mad because, and not to tout my own experience, because I was eliminated from this jury, but I was on jury selection last year, and I just remember the questions that the jurors were asking of both attorneys in the process of selection. And okay, I have a bachelor's degree in it, so I get that it's the world that I've come from, that I've laid out 4 years of my life to studying it. But the basic ignorance of most people, the idea that you could be tried by a jury of your peers. You know, I've said recently that I don't believe in the representative republic or the ideals of democracy anymore. That I've renounced the ideals of the West. But the jury trial, the jury is so easily snowed anymore, and they don't know a person's constitutional rights, and they don't know the elements of a crime, and they don't understand what reasonable doubt is anymore. And if I'm going to court at any point, I'm requesting a bench trial, Drew.
John, this is the most, like, Mark Garagos is one of the most liberal, you know, like, he's definitely a Democrat. He's on the liberal side of the you know, the spectrum, I would say. And I used to listen to his show religiously because I enjoyed his legal views and his opinions, and I didn't agree with all of them, but he's a California attorney, very prominent. He represented Scott Peterson, he represented Michael Jackson, all these cases. But he said very early on, in, we'll call it 2015, 2016, the weaponization of the criminal justice system is the downfall of this country. And he wasn't the only one saying it, but he was saying it in the sense that when you start throwing out sham impeachments and when you start doing all these other things, whether you believe them or not, or like, I don't care where you rest politically, he's saying protect the institution. Like, the Supreme Court came down with a decision the other day, and all of a sudden, to include the president of the United States, started attacking the Supreme Court over it. Like, this is the process.
It's called checks and balances. That's what that is.
And we're supposed to live with it. We need to protect the criminal justice system. This is an example. This is the perversion. This is exactly how this happens. Yeah. Is that what you want in a country? Or do you just want Lady Justice to do her job, hold the scale with the loosely fit blindfold? She's not looking at either side. She's just weighing it. And that's it. That's where it should end. It's not where we're at. And that's why I think this case is important.